certain activities from the automobile graveyard. One of those things, as subsection 2, are area used for automobile hobbyists to store, organize, restore, or display antique autos, antique motorcycles, classic vehicles, horse carriages, or reconstruct vehicles, street rots, or parts of these vehicles. If he has parts of vehicles being stored for the reconstruction of these classic vehicles, then it's not an automobile graveyard. Section 29A MRS 103 subsection 3 specifically defines antique autos, and there is a list of criteria which each vehicle currently stored on Mr. Gaines' property fits squarely into. That's an exemption for the antique autos, classic vehicles, reconstructed vehicles, or parts of those vehicles. That is not considered an automobile graveyard, and that's exactly what's going on at site right now. Mr. Gaines is an automobile hobbyist. He collects these vehicles. He's not scrapping them for commercial sale. For his own use to restore those vehicles, yes. He's not selling the vehicles for parts, and all he's doing is collecting early model Mack trucks and tractors for collection and restoration at his site. This is common activity for someone who would consider themselves an automobile hobbyist. I think we can also look to prior CEO's determination and the town's determination. 20 years this activity went on for with that, and I believe that definition was on the books. Clearly, the CEO beforehand didn't think there was a violation. And I don't know if he was here for 20 years, but for 20 years the town knew of any activity and didn't think there was a violation either. It's not until 2023 when the new CEO came in that there was a misinterpretation of that ordinance and the statutory exemption. I want to stop there, though, and I want to have a discussion with the board about the junkyard and the automobile graveyard. Like I said, if you find that it doesn't meet that definition, or it falls into that exemption, the current use, then we don't have to go any further. We don't have to talk about any conduct of the town, and we can stop there. I invite you to ask any questions that you might have, and if you decide that it is an automobile graveyard or junkyard, then we can go into further discussion.
Do you have a copy of the Title 29A law?
I may. Yes.
Okay.
Did you want to see?
Yeah, I guess our, because I'm not really that familiar with it, of course.
Look at the automobile graveyard
Yeah.
right there. I did outline some of that statutory language in the letter for you. That's what I just circled for you, and that's subsection 3 of that law.
Yeah. So, but is this, this looks like it's part of 30A, this about the graveyard.
That's 30, so 29A.
Yeah.
So can I see what I handed you?
Yeah,
It's like 30 and then Title 29A.
Oh, I
This
see.
is
Okay, got it.
29A.
Yes, my error. Yeah, thank
So
you.
it's 30A.
Yes.
I don't know,
Mr.
MRS.
Chairman, Mr. Chairman, is it
Yes.
okay to ask
Sure,
questions?
absolutely.
Did I understand correctly that after
that's all,
A lot of the stuff, I'm sorry, I didn't mean to cut you off, but a lot of the stuff that we had to get rid of, certain parts that we
Right.
had to take off that we needed for other stuff, so there's storage for the antique vehicle parts
Yeah.
that we need to restore in there as well.
Are those permanent?
We move them in, if they, they can be moved, I mean, I don't know if they're, I don't know what you mean by permanent.
Well,
There's no
you,
foundation on them or anything.
what I'm
like
saying is
that.
did you get a permit to put them in there? I guess that's what I'm asking.
When were they placed on the property?
Within the last 2 years.
So they can remove that, but that's not the issue before the board
No, I
right
know
now.
I understand that.
so, I guess I'd like to, find a definition of what a museum is. Is there one in the ordinance, Craig?
No.
Yeah.
And
Joyce?
If I may,
Yes, please.
I think that, and Ben can correct me if I'm wrong here, when Norm Hutchins issued the permit, quote, quote, number one, a code enforcement officer is not authorized to issue a permit.
Right.
And he should have known, if he didn't know, that the use required a conditional use permit from the planning board. And if you want to refer to the land use table, on page 64 and 65, while the term museum is not specifically mentioned, one of the uses referred is public and private recreational areas,
Is that on page 65?
64,
64?
under 23B.
23D?
Yeah.
Let's see.
Gotta go back.
23B, public and private recreational areas, et cetera. That could perhaps qualify as a
Okay.
museum.
Yeah.
If you go to page 65, under 26J, it addresses indoor recreational facilities, both require planning board conditional use permits in the rural district. If you go to 26N, it talks about visual and performing arts, once again, needs a conditional use permit. If you go to 26R, it talks about other commercial activities, that needs a conditional use permit. And if you go to, on number 28, principal small non-residential facilities for educational, scientific interpretation purposes, it would be my thought if I were asked that a museum would fall under any one of those categories. But I also know that Mr. Hutchins was not the code enforcement officer when he wrote the letter saying that he gave the verbal permit. And I mean,
Yeah.
he just is not authorized to do that. He knows that, or he should have known it for sure. And I would have other comments, but I'm going to, unless you have questions.
No, but I guess the point is, you see it as the way the ordinance is structured, that this type of activity could be reviewed by the planning board and you could fit
Should
it
be.
into,
It should have been.
should have been, and
Should be,
should have been and could be in the future.
yes.
And it would fit into some category here.
In my opinion, yes.
Yeah.
I would also refer to the planning board's notice of decision. I think the gentleman said that we denied it because he didn't have the appropriate information in his application. The application was accepted, a public hearing was held, et cetera. People did have the opportunity to come and speak. And I don't know if they have a copy of our notice of decision, but it addresses a number of issues that go beyond the findings of fact. In the conclusions of law, the representative, I think it was Matt at the time, stated that no work will be done on automobiles or tractors. That's a direct quote from him at that public hearing. The applicant's representative also stated they have not established basic plans as to how or when the quote museum will operate. That's a direct quote. They didn't depict the lot lines. We had no way of knowing at the time what material was within their lot, or what was on a neighbor's lot, et cetera. We addressed the issue of parking spaces, if it were a museum. And we did use the automobile graveyard and junkyard definitions. But the fact that the town, I don't know whether he used the term, allowed this use to happen. I think we all know that there have been instances where things have not been in places they probably should have within the community. But to say that Norm Hutchins gave, or had the authority to give that is, I think, fallacy. And I would question the legality of that decision. But anyway, those are sort of some planning board. I believe you all received a copy of our notice of decision, so you.
Yes. Yeah,
And as far as I was saying that Mr. Gain had the right to come back at any time, anybody has the right to come back at any time. That was just a statement of fact. We were only dealing with that particular application that night, and he certainly has the choice to come back again if he wants to. What his timeframes are none of our business.
Let me ask you this. Were you aware of this exemption under the automobile graveyard law?
Not to the best of my recollection at this
Yeah.
point. This hearing was some time back, and I
Yeah.
don't always remember everything, but I do
Yeah.
not recall that being discussed.
Yeah, okay.
Okay?
Very good, thank you, Joyce.
I'd like to just very briefly reply. We're not here tonight appealing the planning board
Sure,
decision
that's
at
right.
all. Not here really to discuss the open air museum at all. Like I said, I was not at that planning board hearing. I was not representing the Gaines at the time. Their plan is to go back before the board. However, I think one of the biggest takeaways here is nor the CEO, the planning board, or anyone was aware and properly applied this exemption that I believe we fall within.
Okay, any other questions for the board? Or is there anybody else who would like to speak, has standing?
Mr. Chair,
Yes.
I hate to, I'll have some thoughts and instructions to the board. I'm Ben McCall, I'm the town attorney,
Yeah.
for those who I haven't met. This is a public hearing tonight, and so I would suggest that anybody who wants to speak, I don't think you need to have standing necessarily to speak at a public hearing. But once the board has felt that they've heard from everybody who's in the room,
Yeah.
it'd be appropriate for you to close the public hearing, and then you move forward with deliberations.
Sure. So with that, counsel, is there anybody here who would like to comment on it? Yes, sir.
It seems that he's,
You're Jeff Gammon, right?
Jeff Gammon, 31 Moody Road,
Yep.
cab guy, love cars.
Right.
I can't see that this could have been there that long. Slickman has been in the office, who's been to this property, never had a complaint, and he could have really shut it down if he thought it was that bad. All of the Slick code enforcement's gone through the channel, haven't shut it down. Now, we're gonna shut down a piece of history. These cars are all over. They're antiques. Gas pumps, tractors. You ain't gonna take a $5,000 gas pump, I wouldn't think. If it was yours, your money, place it out in the dooryard, you'd put it in a building, which they put in containers to protect it. And same as the parts. You can't find these parts. So you gotta get rid of some, but you can't get rid of all the parts you're gonna use to restore another vehicle just because it's junk to you or junk to me. They need it. It doesn't, you gotta hang on to it or try to hunt it down and buy it. And I just don't think that, take a place like that everyone on that whole loop signed a paper, brought it to the town, said that they were an asset to this community, not a problem. And not bothering nobody, but gotta remove it. And didn't understand. It's antique cars, not a junkyard. A bunch of junk piled up in a heap. It just don't seem right why all of a sudden now We've gotta do something about it. It's an urgent, we gotta clean this place up. No one else complained, they live right beside it. They're not here. Anyone lives beside it here? No? Guess it don't bother no one. But it bothers somebody that lives in Wyndham. It don't bother anybody in Limington.
Yeah.
So, that's my 2 cents, thank you.
Yes, thank you.
I would just say one thing too, as I said earlier,
Pass that
if,
down to this-
if you
those
do
are some
decide that
names.
this is an automobile graveyard or junkyard, I do have a few more points to make. I just want to stop it there so we don't even have to discuss the conduct of the town if we don't have to.
Okay, so, do we have enough information to make a decision?
I mean, I just have one question. When you have this exemption, are you allowed to just have this automobile, as a hobbyist, just have these vehicles on your property without a permit? Or why does it have to be a museum necessarily? I guess that's, can you just have this, like this is, the exemption give you the ability to just have antique cars on your property?
I think it does.
Our position would be that it does.
So the museum doesn't even
No.
really come into play with us.
But like I said, it is the intent of them to share this piece of history with everybody.
I think where the museum would come in, if he wanted to have a public, in a sense,
Viewing.
viewing, might even charge a fee or whatever to come in, like most museums do,
Advertise.
advertise, yeah. That's when it would be something that would need to go to the planning board at that point.
But the exemption allows you to have more than 3 antique vehicles, let's say,
Yeah, under
on
that
your
law.
property. Does the town of Limington allow antique? Because of that, the town of Limington would allow
Yeah,
multiple vehicles, obviously unregistered, tractors and the like.
yeah, if you look at their.
I mean, is that only allowed for farms, or, you know what I mean?
I'm happy to speak to that point.
Okay,
I can do it now, or we can do it once the public hearing's over. I guess I'll put it out this way. The issue before you tonight is an appeal of a notice of violation
right,
that had 2 parts to it, so to speak. There's the junkyard portion, there's the automobile graveyard portion, and the question, it becomes trickier with a notice of violation because the board needs to keep in mind that a notice of violation is issued by the code enforcement officer, but even in a hypothetical scenario where there isn't compliance with that notice of violation, it's still up to the select board about whether to proceed with an enforcement action. We're not really talking about that, but
okay.
to focus on the automobile graveyard portion, because that's where you've spent a lot of your time today. The town of Limington is bound by state law as it applies to junkyards and automobile graveyards. Those are both defined terms in Title 30A, which you've heard reference to tonight.
Yeah.
The basic definition of an automobile graveyard is having 3 or more unregistered or uninspected motor vehicles on your property. Full stop. There are exceptions to that, though, and one of them, the only one that you've focused on tonight, is an exception for an automobile hobbyist. I don't think you've heard any argument that Mr. Gain doesn't qualify as that. It's not a defined term necessarily, but automobile hobbyist who keeps antique automobiles and antique automobile parts on their property. And if you're satisfied, based on what you hear tonight in the totality, that he qualifies as the keeper of antique automobiles, then any antique automobile would not count, even if it were not unregistered or uninspected. Antique autos in Maine, for instance, aren't inspected by the state in the same way that you would for any other car. Those cars don't count towards that 3-car max or 2-car maximum that is an automobile graveyard. So that's the only question before the board, is on the date that the notice of violation was issued. Ironically, we're not talking about what may have happened since then, but on the date that it was issued, did this property qualify as an automobile graveyard? I agree with Attorney Skolnick, and I think the board's already gotten there too, It's a completely separate question that's not before the board tonight about whether or not the property needs to be permitted or will be permitted in the future as an open-air museum. I agree that that's a planning board issue. It's not before you tonight because there was no allegation in the notice of violation that the property was being operated as an open-air museum without a permit. So that is a separate issue that I think it's good to separate because you're not being asked to decide that issue tonight. So to your question, your ultimate question, if the board determines that, and Attorney Skolnick in his appeal has asked you to limit the notice of violation because I think there is the admission at least that there are, and perhaps he can clarify this at that point, how many non-antique automobiles remain on the property. Those, I don't think you're arguing, don't need to be removed. But if you're satisfied that the remainder of them count as antique autos, then that's grounds to grant the appeal.
Could I hear from you, Matt, again, please?
Yes, sir.
Yeah. So to that point, are there, other vehicles there that do not meet the standard for an antique auto?
I'm going through my head right now. There's maybe one or two. One.
Okay.
And we're using parts off that for something else, and that's probably likely to go away shortly.
Yeah. So even though there is one, it doesn't spring until it gets to 3, right?
Correct. You're allowed to have two, without any penalty or requirement, you're allowed to have two unregistered, uninspected, non-antique
Yeah.
motor vehicles on your property without it being considered an automobile graveyard.
Yeah. Okay, thank you, sir. So if we don't have other questions, we can close the meeting, discuss this, and vote on it.
I'd just suggest asking whether Attorney Skolnick has anything further, whether there's anybody else in the audience who'd like to speak, and then I agree with you completely. Sorry, Limington.
I would just ask, and I hope we're getting to the same place, that you vote on the question of whether
Yes.
this qualifies as an automobile graveyard or junkyard, not whether to grant the appeal or to deny it at this point.
Right.
'Cause if not, then we have to go into other topics as well.
Yeah. Okay, thank you. So, we will close the meeting for the public hearing part of it, and now we'll go to discuss it and vote on it. So, where do we all stand?
Do you want to do findings with that?
Yeah.
Bev, I'm happy to draft the findings of facts
Oh, okay.
for this. I'm here, it's part of my job.
Okay.
The only thing to keep in mind for the board, before you dive in too much, is
Right.
I'm not gonna be able to finalize them tonight.
Oh, no, that's fine.
You're required by state law, I hate this,
7 days?
7 days, yes, you know it very well. So I can definitely have them ready for you in 7 days. You just need to remember that you'll need to meet again in a week's time in order to approve those findings. So I'll have draft findings for you, regardless of your decision, well in advance of that. But I just want to put that on your radar. Your other option, I suppose, is if you don't want to trigger that 7-day period and you need to, I would caution you against delaying this any more than is necessary, but in theory, you could discuss the matter tonight, come to a consensus without having a final vote on these two issues of automobile graveyard and junkyard, but delay your final vote and then the adoption of findings for a meeting in 2 weeks or 3 weeks. It doesn't need to be next week, but if you do vote tonight, which is fine,
Yeah.
you need to be able to finalize and adopt your findings in the next 7 days.
Is it your opinion that once you prepare those findings, that if you emailed it to all of us, would we actually have to, under the law, meet? We would?
Yes, you
Okay.
need to meet at a public meeting that's noticed in the same way that it is there. You wouldn't need to have a public hearing, so you wouldn't need to allow public comment on that. It would just be for the purpose of the board reviewing draft findings that are prepared purely as suggestions for you to consider. You can make and should make whatever edits you think are necessary, but any public business of the board,
Yep.
including adopting those findings, needs to happen at a public meeting.
Right. So,
Mr. Chairman,
yes.
I'm going over in my mind what I anticipate the finding of facts would be. It seems the nexus of this is determining whether or not this property qualifies as an automobile graveyard. What I've heard from our attorney and people around their table, that it does not. I'm trying to think of what other findings of fact would be appropriate as part of an action that we would need to take.
So you have been asked, and I'll try and explain this as best I can. You have been asked for a determination that the property does not qualify as a junkyard. Now, this is more complicated of an issue than perhaps it looks at face value, because again, the appeal is from the issuance of the notice of violation. It is quite possible, and it seems as if there's testimony that you've heard tonight, that since the date of the notice of violation, that there has been compliance with that notice, and what has been removed from the property, to the extent it existed already, was that junk. Perhaps I'm misinterpreting well, can I finish? That's a separate, that very well could be. That is a question, though, about whether any additional steps are necessary from the town's perspective in order to follow up with what is written in the notice of violation. It's a different question about whether on the date it was issued, there was still junk on the property that needed to be removed. It's my opinion, at least, that if there was junk on August 8th, when that NOV was issued, that would have qualified as junk under the definition of junkyard, the board could find that's sufficient to uphold the finding that on that date, the property did qualify as a junkyard. But at the risk of complicating things, even if it were a junkyard on August 8th, it doesn't necessarily mean, I'm not saying one way or the other, but it doesn't necessarily mean that it would qualify still today, or at any date prior to that.
Do you have evidence of the 17 slips?
17
tonight?
trucks. No, I don't.
That was from a year ago.
That was, so just to clarify,
That was before. Sorry.
yeah,
Oh,
so
I hear you.
the 2023 notice of violation, then everything was cleaned up, and then there was an issuance of
Well, that's
additional
30 days.
violations.
Yeah.
So nothing's happened
I think
since
we could
the
just say,
violation that we're
Next up,
appealing
this
tonight
part right
and
here.
now.
So just to
And
clarify,
keep-
Mike, for
keep
my
this
for my
right
own
here.
edification, so it's your
Right.
client's position that not just that more junk has been removed from the property since the 2024 NOV was issued, but that it was improper on the date it was issued because there was no junk on that date.
Yes.
Okay. Then I'll
Right, so in that 30.
recalibrate my statement to match what Mike is saying his client's position is.
It seems like to me that one of the simple ways of doing this, and maybe I'm oversimplifying this, but in the CEO's letter of August 8th, that portion that's in bold, please remove all unregistered and junk automobiles. That if we rescinded that part of it, and then you could still keep the other part of trash and debris. That's always been something they've been working on, and so that part would still hold, though. The trash and debris, if there is any.
The junk.
But and maybe that's cumbersome, and maybe we should just think about in terms of saying that this is he is exempt from the automobile graveyard law in our ordinance. because of his exemption for those antique autos?
So I think there are two separate questions, and based on what was just represented, I think it's important that the board make findings as to each. So, as part of the August 8th notice of violation, it says, that, the allegation is that the property qualifies as a non-permitted junkyard and a non-permitted automobile graveyard.
Right.
What you've heard tonight is the property owner's position that on August 8th, there was no junk, and there is no technical definition of junk. There's only a definition of junkyard in state law that has a list of qualifying
Yes.
items.
Right.
But the position that you've heard tonight is that there were no such items on the property on that date.
Right.
As to the automobile graveyard, you've heard that on that date, there was one unpermitted or unregistered and or uninspected motor vehicle, and that the remaining motor vehicles on the property would qualify as antique autos under the statute. And so I think it's important for the board to make findings that on August 8th, when that notice of violation was issued, based on all the evidence you've heard tonight, did the property at 20 Hemlock Lane qualify as a junkyard? Yes or no? Did the property qualify as an automobile graveyard? Yes or no?
Right.
I agree. In theory, you could grant the appeal in part and deny it in part, but in order to simplify the whole thing, I think
Yep.
just answering both of those questions,
Yes or no? Yep.
yes or no and why,
Yes.
is important, and that'll help me formulate some draft findings for you.
Okay. So let's take the junkyard part of it first, okay? So we've heard testimony that it's been substantially cleaned up. That's the language that I'm hearing. So what's our view of whether or not there existed a junkyard on August the 8th, 2024? We can put it in a motion if you'd like, and you could move to say that, to vote on whether or not there is was a junkyard there on August the 8th.
I move that.
You wait one second, let me
Yeah.
flip. I just gotta flip.
Didn't he come?
He came, but who
Yes,
knows?
okay.
We don't trust anything. That's Don, we don't trust anything. Well, this isn't working either, so go ahead. Go ahead.
Oh, wait, you must be able to get that.
There we go.
There you go. All right, good.
Now I lost my train of thought. I
Sorry.
moved that no, I'm teasing you. I moved that the board, that as of August 8, 2024, that 20 Hemlock Lane was not a junkyard under rules and regulations in the ordinance.
Okay. Do you have a second?
Second.
Second by Gary. Any discussion on that motion? If not, all those in favor of the motion as presented,
Aye.
it's a positive vote. 4-0. Let's move on down to the question about the automobile graveyard. And
I move that the board finding is that the property at 20 Hemlock Drive does not meet the statutory requirements for an automobile graveyard.
we have a second?
Second.
Second by Gary. Any discussion?
Does this, Mr. Chairman, necessitate a revision of our ordinance?
Well,
Or is the ordinance explicit enough with a reference to 30A?
Well, yeah, you see, our ordinance doesn't spell out what 30A is in the ordinance, but it does refer to it, so it goes back to the statute. And that statute has this exemption in it.
Right.
And so if we wanted to change that and take out that exemption, I think you can always do that. You can make something more stringent than state law. You can't do that, no?
That rule applies differently in different
Okay.
places. So, the town could, and this is an issue for town meeting,
Sure.
not the Board of Appeals necessarily, the town
Right.
could, a lot of municipalities in Maine have a definition, not necessarily of automobile graveyard, but prohibit people from having more than one unregistered or uninspected motor vehicle on their property.
Yeah.
The statutory reference to antiques, in fact, does include a provision in there that says municipal ordinances may not more stringently define the
Okay.
hobbyist exemption. So
Very good.
there, the legislature has told you clearly what you can and cannot do.
Very good, all
Yeah,
right,
that makes sense.
all the better.
I was really interested in
Yeah.
helping our code enforcement officer with that piece of the law that's pretty obtuse, and that he acted on what he thought
Yeah, he
was
did.
appropriate.
That's right,
And
He did.
that's what we pay him to do.
that's right, exactly, yeah, yeah. And this is why we go through this process, you know? This is a civil process, and it'll be that way, yes, sir.
I still think you haven't had a vote on the.
No, we haven't had a
second
vote.
question. Just making sure it's
Yeah.
not lost in the fray.
So, we've had a second, and all those in favor of that motion,
Aye.
positive vote. Okay, now, let me ask you about the timing of this. So you say it's gonna be 6 or 7 days, probably, before you can prepare the findings.
Fewer than that.
Fewer than that. So, and then, and once that's done though, see, I always understood that we had to give them a notice of decision within 7 days. So, I find it cumbersome to, you know, we can't even get the notice out to have another meeting within the time frame of 7 days.
I wish you would tell that to the legislature. From a practical perspective,
We've never done
I can have findings to the town by the end of the week, so you can adopt it. I think it is the law on this point is clear that because I've interpreted the board's vote tonight as granting the appeal.
Right.
The date of appeal rights begin tonight,
Yeah.
or I guess technically begin tomorrow. Not on the date that you adopt your decision, but the state statute says that you need to mail the notice of decision within 7 days. And so,
Okay, yeah,
technically speaking, if you didn't do that and it interfered with an appellant's ability to appeal to Superior Court, there may be a question about what the exact timing of that is, but I think from a practical perspective, if you've adopted your findings and provided them to the applicant and to the code enforcement officer and everybody else within that 7-day period, I'm comfortable with that.
but we can't supply them until we vote on it, right?
Correct.
So what's the quickest meeting that we could possibly have under the
I want an
notice,
email.
the
Next
notice
Monday.
requirements?
Probably next Monday.
We could get something in the shopper's guide, or how do we do it?
It's not a public hearing, so it doesn't need to be noticed that
Okay,
way.
I guess that's what I'm
Um,
missing. Yeah.
So,
Next Monday's a holiday,
so next Monday is a holiday. You know,
Tuesday.
you provide notice in the same way that you would, not notice as a public hearing, but notices of any other meeting, is you put it on the town calendar and
Okay, good.
on the website and provide notice to the applicant, of course.
Yeah, so what's everybody's schedule next Tuesday?
The 15th.
Yeah,
I don't have my
Same.
calendar with me, I'm sorry.
yeah.
You can just pretend this is it.
That's
Black.
fine.
I can't imagine it would be a very long meeting.
No, I wouldn't.
So the only thing,
Okay, I have a question. Could we
Yeah.
meet during the day? I mean, like 5 o'clock or
We could,
5:30 or 6 o'clock?
next week might be hard for me,
Okay.
just because
Yeah.
I'm leaving on vacation for 10 days.
Do you, what
Yeah.
do you
Oh,
would
poor
so
you.
is even Tuesday good for you, Gary?
I'm backed up.
Even Tuesday, is that good for you or not?
Well, I saw an email today, we might have a financial advisory committee meeting on Tuesday.
For this, town of Limington, right?
Yeah,
Yeah.
but could we do it before that? I mean, what are we gonna take,
Sure.
10 minutes?
Yeah,
That's fine.
yeah.
I don't know if there's a meeting, they don't, the chair doesn't even know.
So what time?
I thought it was this Thursday, people think next Thursday,
So what,
Tuesday.
what time do you meet?
Seven, I mean typically Thursday after the select board, so probably 7. I'm not,
Okay.
I'm not sure. We've lost our secretary, so I don't know.
So, well, I guess.
I mean, if we
I'd
need to
like-
meet, we can meet.
Yeah, I'd like to shoot for Tuesday if we could. And,
mean, it shouldn't take-
whatever is convenient for people. I don't know if 6:30 is good,
Make it work.
That's fine.
you know? That way we can all get home before dark.
No, not quite.
Is anybody gonna be surprised by our NOD on this?
No.
No,
You just,
just a
it- it-
formality.
it's
Yeah.
ministerial, but you do need to review it.
Yeah,
Okay.
For completeness and for consistency with your reasoning. I'll
Yeah.
obviously do my best to make sure it is that way. It's ultimately the board's decision, but you just need
Yeah.
a formal vote with all of you here, to adopt that
Yeah.
decision either as written or as amended.
and then immediately after that, if we did it on Tuesday, we could have the notice in on Wednesday, which is mailing it on the 7th day, I guess.
Provided to the, email exists too, and so I'm
But even if we're a day or two late, no harm, no foul, right? Okay.
Do we have to notify, who do we have to notify of this meeting?
it's a public, I
It just puts it on the website.
it's a
it says.
public meeting, however, I mean, whoever else you would notify, but it doesn't need to be noticed in the same way that you would a public hearing in terms of newspaper notice and
Yeah,
Right,
and the remainder. I'd post it on the town website. I'd send it, if town, if the select board gets notice of those things. I know you have a select board member.
what about the gains, we'd have to notify?
Well, absolutely,
Right.
yes.
Oh, yeah.
Yep.
Right,
But I think they're here tonight too, and they also hear that you're gonna be meeting at 6:30 next Tuesday as well, so.
tomorrow, or?
But it wouldn't be, this is not a meeting, you've closed your public hearing, so you won't be taking additional public comment unless for some extraordinary reason you choose to reopen it.
Yeah.
Your only goal would be to go over with a fine tooth comb, the draft findings that you have prepared for you, and then, ultimately adopt them with amendments or without.
so as a matter of procedure, do we need to vote on a meeting date next week? Or no? We just agree?
I don't think so, I think that just happens,
Yeah.
not by osmosis, but,
Okay, so let's shoot for 6:30? Is that good?
Fine.
Is that good? Okay. All right, let's shoot for 6:30.
good?
On Tuesday, the what? 15th? And so technically, we don't really close out this meeting, do we?
You could have, if you choose to have a final
Continuation.
vote, on whether to grant the appeal or not in totality, I suppose you can do that, although I think read together, your 2 votes tonight do that. You've granted the appeal,
Right.
You would adjourn the meeting, but it's a separate order of business is to review and adopt findings
Okay,
of
good.
fact for this decision in the next meeting.
So I'll take a motion for adjournment. So moved. All in favor? Very good. Thank you. Thank you, everybody.
Thank you.